Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. All right, well, welcome back to another episode. Jeff, one of the things that you've been really fortunate to have on your website and on your Facebook page are a series of client testimonials where people have actually come back into the office and talked on camera about some of the work you've done. Now, in one of those previous client videos, the lady made reference to the fact that you're still fighting, kind of going a little bit higher on appeal regarding some benefits. Do you kind of want to bring us up to date on that? And we'll actually launch a larger topic here, talking about the Kentucky Supreme Court and some things you're involved with right now.
Sure. The lady that did that video testimonial, we've been successful in her case in having the benefits awarded. Her injury occurred prior to 2018. In 2018, the Kentucky legislature changed Kentucky's workers' compensation law, and that's happened several times during my career that the laws changed. But one of the things they did in 2018 that is unusual for the legislature to do is to say that some of the changes that they made in 2018 were retroactive to cases that occurred before 2018. And that was what we're fighting out about in her case. I've actually, right now, I have four workers' compensation cases at the Kentucky Supreme Court. Two, the employer filed the appeal to the Supreme Court. Two, I filed the appeal to the Supreme Court. Two of the cases are dealing with or three of the cases actually are dealing with retroactivity of certain provisions of the 2018 case or statute, but two of those are the issue that lady was talking about, and that issue is the termination of income benefits at age 70.
And let me back up for just a minute, because this is really interesting, and it just astounds me that this happened. Basically, you had reached a successful conclusion to the case. This person's benefits were assigned. The case was, for the most part, done. But then the legislators get together in 2018, pass a law, and say, "Oh, that deal you agreed to, yeah, we're going to change the terms retroactively. We're going to reach back and change that."
To some extent, what the legislation said was that any cases that are still active at the time this law takes effect, this law would apply to those. The retroactive parts would apply to those cases. Normally, when a statute is passed, Workers' Comp Act is passed, the law in Kentucky is and has been for a long, long time that the law in effect at the time of your injury is what controls your claim. So any changes to the law after your injury date doesn't affect your claim. What they did, at least with certain parts of the 2018, is said if your case is not completely finally resolved, then this law, some of these changes would affect your case, one of which is cutting benefits off at age 70 or 4 years, whichever is the greater of the two there. And what happened is cases that were not final at that point that would affect the insurance company, and their attorneys appealed those cases to make sure that they did not become final until after this law become effective. The 2018 bill was filed as a bill on February 18th. I'm pretty comfortable because I just finished up a brief to the Supreme Court on this issue. So February 18th is when the bill was filed. One of the cases I have, the judge's decision awarding my client's benefits occurred even prior to that date, shortly prior to that date, where they awarded my client benefits for a period of temporary total disability, about 6 months, if I recall correctly, and then 8 years of permanent disability benefits. My client was 67 at the time of injury. So this law is going to take away more than half of the benefits that the judge awarded to her if it's allowed to have that retroactive effect there. When the judge made his decision, the bill hadn't even been filed, but it got filed shortly thereafter. So the insurance company filed the appeal to the Workers' Comp Board. The Workers' Comp Board decision become down before the actual statute become effective, and they said we can't apply a statute that's not yet the law there, and then they appealed it to the Court of Appeals, and now, unfortunately, the Court of Appeals said, yes, it can be retroactive, so I've got that issue on appeal to the Supreme Court. In that case, in another case, I've got the same issue, and there's 2 other cases, so there's 4 cases right now that have that issue before the Supreme Court of Kentucky that all have come out this year, went up to the Supreme Court this year. 2 of my cases, one actually the other 2 cases I think are both Eastern Kentucky attorneys that have those. The client that gave her testimonial mentioned that I had the issue at the Supreme Court already, and that was a correct statement. It wasn't in her case that it was at the Supreme Court. There was a case that actually went to the Supreme Court that was at the Court of Appeals when the statute was passed, and they added the issue on appeal to the Supreme Court that the 2018 law should take effect. And I was involved in writing an amicus brief to the Supreme Court in that case. An amicus brief, for those who don't know, is sometimes referred to as a friend of the court brief. It's a brief by someone who has an interest in the outcome of the case but is not a party to the case. In that case, the amicus brief I helped on was filed by the AFL-CIO, which takes a great deal of interest in workers' compensation matters for their labor employees, or their labor members, I should say. So I was involved in that to try to get that law changed. The Supreme Court punted in that case instead of deciding the constitutional issue, saying that it had not been preserved below because it had not been presented to any at the courts below. So they basically said it's not been properly preserved, so we're not going to decide that issue.
Wow.
Which made us have to, unfortunately, keep appealing a lot of other cases to get the issue back before the Supreme Court, but now it's back before them, and hopefully before the end of this year we'll have a final resolution on that.
You know, what's interesting, though, is in pages on the website and previous podcast episodes, things like that, we've talked about the fact that you will take cases as far as they need to go on behalf of your client when it makes sense to do so. And here's a prime example of you at the Kentucky Supreme Court on behalf of injured Kentucky workers, and that's just fantastic. You know, to sit here with you and have somebody that's able to do that at your level, it's awesome. I mean, it really is.
Well, and I appreciate that, and yes, I will take the case as far as it needs to go for my client, and even take actions like on the amicus briefs. One of the cases that's there now, I authored, the one who drafted and wrote and filed the amicus brief on behalf of the AFL-CIO in that case, as well on one of the other cases that got there, the very first case that got there, which was not my case. It got there a few months before my case, but I even though didn't get paid anything to write that brief, I wrote that brief and filed it on behalf of the AFL-CIO because it will have a great deal of impact on my clients and on injured workers in Kentucky. And as you know, because we've talked about this before, but I'm active in trying to get the law changed through the court system to make it better for injured workers and for my clients, and also somewhat active in the legislative field, talking to our local legislatures about workers' comp and other areas of law that I'm very familiar with when they have bills presented. The 2018 bill, I went and talked to a lot of legislatures about the impact of this bill and what it was going to do to injured workers. Unfortunately, myself and others who did that weren't as successful as we had hoped we would be there, partly because I think actually I know the legislature was somewhat misled by one of the witnesses who said that this bill would not affect anybody who was injured before this law takes effect, when the bill specifically said, yes, it
That's
does.
What's going to happen. That's exactly what
exactly. So,
wow.
I mean, that, but unfortunately, that carried the day to some extent, and the bill got passed anyway. So,
wow. Well, in dealing with the Supreme Court right now and some of these changes that occurred under the 2018 Kentucky Workers' Comp Act, there's also another factor that's concerning, obviously, is the reopening of a case, if someone needs to attempt to increase their benefits. Do you want to kind of, describe that and kind of get into that for us a little bit?
Yeah, sure. And that's actually one of the other cases. The employer filed that appeal, but one of the other cases I have at the Supreme Court's on that very issue. Before 2018, when you had a work-related injury, workers' comp is different than a lot of other litigation areas. A car wreck, when the case is settled, it's over and done with. You cannot reopen it and go back in and get any more money or show there's been a change of circumstance. Workers' comp is different. Workers' comp has, for a long time, had a provision that if your occupational disability changes, if it increases, you can go back in and seek increased disability benefits. If it decreases, the workers' comp insurance carrier can go back in and argue that what you've been awarded should be reduced because you're no longer as disabled as you were at the time of the original award in the case. And that's been part of the workers' comp law ever since I've been practicing, starting in 92 forward. They put a limit on that to say that it had to be within 4 years of any previous award. So, previous award or order. So, if the judge made a decision in 2010 awarding benefits to my client, and then 2013 the insurance company filed a medical fee dispute, and we were successful in getting medical treatment paid for my client, then we would have another 4 years from 2013 to file, and it would keep going every 4 years from any order that we could reopen. In 2018, they changed that to say you have 1 4-year period of time from the original award or settlement, and that's it. So in 2010, the award in 2014 would be the last time you could file a reopening for that. And they said that applied to cases that occurred even before 2018. The case I have at the Supreme Court is one that we were successful in reopening. The injury occurred in 2007, I believe, and there was a couple of reopenings on the case, and then we filed a reopening in 2017. And were successful in that reopening and had benefits awarded to that, and the employer basically appealed because they knew the statute was at least said to be retroactive, and so they've argued that even though when we filed the appeal or the reopening in that action and were successful before the judge, that this new law should go back and say that my client could not have filed in a reopening then because their time frame expired 4 years after the original injury in 27 or original settlement in 2017 or 2009, whenever it was.
Just really some legal maneuvering to try to use a new law to vacate an older decision like that.
Exactly, and the legislature. I have an idea, but insurance companies and business interests contribute a lot more money to legislators than injured workers do. So they have a little bit bigger voice there, and that's just the way politics is, unfortunately. But hopefully the Supreme Court of Kentucky will state that no, we're not going to let the legislature go back and try to change the law before and take away benefits that were awarded to people even before this statute took effect. That it will apply from July 2018 forward, but we're not going to let it apply to cases that occurred before July 2018.
Well, and just as a layman listening to this, it just seems astounding that they could actually do that anyway, or that they would think that's in somebody's best interest to do that when you've got an injured worker who, basically is doing what they can for the company, and then the company cuts them off at the knees like that. I mean, it's unfortunate.
Yeah.
And that's even more important if you're a younger worker who's critically injured.
Correct.
Because you've got a longer life expectancy, and things are going to change and develop over time. So that 4-year window doesn't really make a lot of sense if you're 28, 30 years old when you get injured.
Well, and exactly, and it makes a huge difference in that regard because permanent partial disability benefits in Kentucky are limited. They continue for 8 years or just a little over 8 years, 425 weeks, or they continue for 520 weeks, depending on the disability rating that the person has. So if you got a 25-year-old who has a partial disability, that's going to end at 35. Even though their disability continues for the rest of their life,
exactly.
The income benefits stop at most after 10 years. Well, if that person, after 4 years, if they have, say it was a back injury, for instance, and then they have a deterioration, have to have another back injury or 2 or 3 more back surgeries after that first surgery, and then become totally disabled more than 4 years after the original decision or settlement or award, then
they may be on their own.
Yeah, they're on their own. They're getting basically governmental benefits, either Social Security disability benefits, if they paid enough into the system in Medicare, or they're getting SSI disability and Medicaid, something of that nature, instead of the insurance company who got the premium dollars to cover this person having to cover them. And the thing that rubs me the most is if I'm successful with my client in having them found totally disabled, 20 years down the road, the insurance company can go back in and say, well, they're no longer totally disabled. They can reopen at any point during the rest of that guy's lifetime or that client's lifetime to have a permanent total disability reduced from a permanent total disability down to something else, but the injured worker doesn't have the same.
It doesn't go both ways.
It does not go both ways.
Wow.
And that just, to me, if you're going to have it, if it's good for the goose, it's good for the gander, in my opinion.
Well, I would think so. And this is, I guess, the third part of that. And it sounds like it's really, really related to what we just talked about. But, you're no longer guaranteed necessarily lifetime benefits, which under Kentucky law is kind of a nice thing for workers' comp. But 2018 kind of changed that.
2018 changed that. There are certain injuries that still get lifetime medical treatment. If you're totally disabled, if you're found totally disabled, you get lifetime medical treatment. If you have an amputation of any sort, you get lifetime medical treatment. Blindness, you get lifetime medical treatment. And so there's certain injuries that automatically give you lifetime. But most injuries now, they've taken away lifetime medical treatment to some extent. It's not completely taken away, but you've got a guarantee of 15 years of medical treatment with the potential to get lifetime at the end of that period of time. So, if you had an injury, now that's not retroactive. That was from 2018 forward. So if your injury was before July 14th of 2018, you still have lifetime medical treatment for your injury. So
there's a grandfather. It's grandfathered in at that point.
Anybody whose claim is resolved and they're worried that they don't have lifetime medical, no, you still have lifetime medical if it was before July 14, 2018. But for injuries after that date, then the medical is at the end of 15 years. The problem with that is, and obviously we're not 15 years after it, so I'm not seeing the effects of this yet. But what we're going to see is people have changed addresses. Some people live in the same place for years and years and years, and other people change fairly regularly. So the persons where they are at the time their claim resolved, their address is going to be different 15 years from then than it was at that point. And the Department of Workers' Claims has to notify them, send out a letter saying 6 months before, saying the 15 years is about up. If you want to seek lifetime, you got to file the proper documentation to try to get lifetime medical. And at least my understanding of what they're proposing is it's going to be the injured worker's burden to make sure the Department of Workers' Claims is kept up to date with the address. So if you change your address, you've got to let the Department of Workers' Claims know your new address for that 15-year period of time, so you get that documentation. And if you don't get it, so you don't file the paperwork, unfortunately, you're going to lose the ability to even seek lifetime medical treatment. And if the insurance company is aware of it, at least we've advocated, and I'm hoping it's going to become part of the regulations that if the insurance company has a new address or a different address and the Department of Workers' Claims sends that letter out to, they've got to notify the Department of Workers' Claims that they have
There's another address.
That there's another address, because they're sending checks out to the injured workers for a minimum 8 years on partial disability cases, unless it's settled on a lump sum basis. So they may have a different address than the department does, but the injured workers need to make sure they keep that address updated with the department if you've got an injury after 2018.
Is there a form or is there a website that you're aware of that may have that information so that an individual can make those updates? Here's the thing. I think a lot of people assume, well, I did a forwarding of address. I moved and I went to the post office and I said, well, here's my new address. Send my mail this way. That only lasts for about a year.
If that long.
Yeah,
exactly.
Yeah. So that's not the route you got to take. You've got to go back to the workers' comp system.
You've got to let the Department of Workers' Claims themselves know, and they're developing the process to do that. They may have developed a form now, but frankly, I don't know that it's not going to even be used for another.
It's only been 2 years.
Yeah, it's only been 2 years, so it's going to be another 13 years before it ever kicks in. There, so
it's the government. We might be able to hit that deadline.
Yeah, so the forms that they're working on now will probably change between now and then. Technology is going to change between now and then. Right now, and one of the things that I and others have advocated is get not only the street address or mailing address, but get an email address for the individuals and other things. Now we're able to keep even when we move, we're able to keep our same phone number, cell phone numbers, and things like that, and do that, and then reach out to them through every different avenue, not just sending a letter in the mail to the individual, but sending an email, sending a text message. Phone calls, social media, reaching out that way, things of that nature, to make sure the person is properly advised of their time frames and the deadlines coming up.
Well, and if I'm an injured worker, I may think, well, my attorney's going to keep me up to date on this, won't they? They'll send me a letter. Well, I'm sorry, 15 years down the road, somebody may have retired. Somebody may have left the practice. So suddenly that attorney is no longer in place to do that for you. So, this is really, as an injured worker or the caregiver for that injured worker or somebody that maybe has power of attorney, they really need to be proactive on this. Granted, we have some time still. We've got 13 years before this really happens, but you need to have a game plan.
True, and exactly. Your attorney may not be practicing anymore from that standpoint. And the Department of Workers' Claims will send out things to, I get documents if the insurance company files a medical fee dispute on a client of mine from 15 years ago, they'll send me letters to that, but they'll send it to my P.O. box that I haven't used in 6 years, but that's what I used back then. So that's the address they had on file for that case. They know me because I do so much workers' comp there, and know the commissioner and others at the Department of Workers' Claims. So when it comes back undelivered, they okay, that's right, he doesn't use this anymore. Send it to a street address and do that. You and I were talking before we started the podcast that the first 8 years of my practice, I practiced with another individual, and he passed away in 2000. And late last year, earlier this year, a medical fee dispute was filed on one of the cases that he'd handled, and we got a letter at the office because I'm in the same building that I was in when I practiced with him. We got a letter at the office addressed to him on a medical fee dispute, and he's been passed away for 20 years now.
Well, and the challenge here again is to not to assume it's going to just be handled. If you're receiving these benefits, you need to be informed. Have that conversation with your attorney, have that game plan, so at least you're aware of it, and do your best to keep up to date. Right. It's not always possible, but you got to make an effort here. Yep. So Jeff, just out of curiosity, I've got to ask. I'm sure people listen to this. You've got a number of cases up at the Kentucky Supreme Court. What's that like?
Well, I've been there multiple times in my career. I've looked at it at one time, and now I can't remember how many times I've been up to the Supreme Court, but it's a lot in my career. This is the first. I've got 4 active cases at the Supreme Court right now, and that's the most I've ever had at any one time there. But it's I've been there so much now that it's not quite as exciting as it once was. to be there. The kind of a at least interesting side note is I started practicing with that gentleman that I talked about in late October 1992, and I do remember that over the Christmas holiday of that year, I was in the office working on a Supreme Court brief on one of his cases that we were filing a discretionary review at the Supreme Court on. So I got started working on Supreme Court matters fairly early in my career. From that standpoint, and I've had several cases at the Supreme Court, and it's always nice to be there. Even though I've been up there 20 plus times, I've only had one oral argument at the Supreme Court, which is kind of odd. I would have thought I'd had more, but I've only had one oral argument with the Supreme Court.
So a lot of it's based on the briefs, the documents that you provide, the arguments that you make on paper.
Yes,
basically getting to that point.
Yeah, and that's the way most Supreme Court cases are decided, or especially in the workers' comp field, which is what the majority of the cases I've had at the Supreme Court have been in the workers' comp field, and they nearly always decide those on the written briefs as opposed to having an oral argument. The one oral argument I did have was in a workers' compensation case, but that's and really I think that's about the only oral argument I've ever recall hearing in a workers' compensation claim at the Supreme Court level.
And that's where the justices will actually, there's a give and take. They're asking you questions live. You're standing in front of the podium or however that goes, and that goes back and forth for a while.
It does, yes. You got a set time limit that you have to make your points that you want to make, and as you're making your points, they will interrupt you frequently and ask questions, and you've got to stay on your game plan and obviously answer the questions they ask.
They're going to let you know if you don't.
Yeah, they will let you know if you don't, and it can come back to hurt you and your client if you don't. But also remember where you were at in the points that you were making, so that once you answer that question, you can go back, because sometimes the questions are completely different on different topics than the point that you're making at the time that they ask the question. And you got to pay attention, because if they're asking that question, it's something important to them. So you need to make sure you're addressing that, because if they're asking the question of you, they're asking it because they have a concern there, and you need to quell that concern or explain why they should rule in your favor on the issue that they ask you about.
But to your point, you've got to crawl back out of that rabbit hole and continue on down the trail.
Exactly.
Wow, yeah. That's amazing, Jeff. Well done, guy. I mean, that's pretty incredible to have somebody that's been up to the Supreme Court that many times. Not every attorney in their career, his or her career, is necessarily going to argue in front of the Supreme Court. I mean, that's I won't say it's unique, but it's kind of special.
Like I said, I'd been there several times before, because the time I argued before the Supreme Court was in 2016, I believe, 2016, 2017, and I may be off on the date there. So I had practiced and been at the Supreme Court multiple times before that without having an oral argument at the Supreme Court level. So it's something, and there are some attorneys who do, I mean, their practice is an appellate practice, and so they take cases on appeal and do that. And those attorneys obviously are going to argue at the Supreme Court much more frequently, because their practice is strictly focused on doing appellate court work.
An appellate court, that's the appeal, basically.
Yeah, the appeal. Yeah. The initial appeal normally is to the Court of Appeals. Workers' comp case goes to the Workers' Comp Board first, and then to the Court of Appeals, and then the Supreme Court there. So somebody who does nothing but appeal work is going to be there more frequently than I am. But in my practice, it's been interesting to be able to practice as frequently at all levels of the court system in Kentucky.
Well, again, when you sit across the table from somebody and say, I am willing, if necessary, to take this all the way, you can back it up, and that's
I can point my name out in the legal books where I've won cases before the Supreme Court, and unfortunately, my name's there a time or two. I've won more than I've lost, but it's there on a couple of losses. I think the last time I looked at it, I had around a 75% success rate at the Court of Appeals and Supreme Court combined.
Wow. Well, there's no sure bets in law, but
absolutely
it's
not.
all about the batting average sometimes.
So
there you go. Well, Jeff, it's been a pleasure. I really appreciate your time. I know you're busy. And friends, if you found this interesting, I would encourage you to subscribe to the podcast. You can find the podcast on Apple iTunes or Apple Podcasts now, Google Podcasts, and a bunch of other areas. When you subscribe to a podcast, that doesn't mean that you're signing up for something that you're going to have to pay money for. In the world of podcasting, if you subscribe to a podcast, it just means you're going to receive a notification when the next episode is available for you to listen to. So if you take a look at whatever device you use to listen to your podcast, and there's usually a big subscribe button, go ahead and click on that, and we'll be back with you in about 2 weeks. Jeff, again, thanks for your time.
Thank you.
Yeah, bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of a small town service and big city results.